Tuesday, lawyers for Muslim parents and two pairs of Roman Catholic parents argued to the United States Supreme Court that certain books read to their children as part of the public schools' storytime curriculum violated their rights as parents under the First Amendment's Free Exercise Clause. I submit that the case should have never reached the court, and I'll offer at the end a short opinion I would submit if I were a justice asked to explain why. I understand why these parents objected to the view of human sexuality and human meaning presented in the books. My problem isn't with them, it's with the lawyers and particularly the justices. Reading the transcript of the oral argument was the legal equivalent of reading a nonsensical script of an existentialist written for the theater of the absurd. But for the sake of brevity and to justify my constitutional analysis, I will focus on this one comment by Justice Kavanaugh, who lives in the same county as the complaining parents. Quote, "I guess I'm a bit mystified as a lifelong resident of the county how it came to this." What I found mystifying is that Justice Kavanaugh or any of the justices should be mystified as how this constitutional problem came to be. The fundamental problem in this case is that no one even asked if the First Amendment's Free Exercise Clause should apply to a state issue like this. Consider the amendment's full text, and I'm going to give you the punctuation because it's very important. Quote, "Congress shall make no law respecting an establishment of religion, comma, or prohibiting the free exercise thereof, semicolon, or abridging the freedom of speech, comma, or of the press, semicolon, or of the right of the people peaceably to assemble, comma, and to petition the government for a redress of grievances, period," end quote. Now, my 7th grade English teacher, Captain Russell Tate, God rest his soul, who taught me how to diagram sentences, would have asked me to identify the subject of the sentence. In my diagram, I would have identified the subject of the one entire sentence as Congress. And if you see any other subjects in that sentence, I would suggest you need remedial education. But for the sake of a video, I turned to AI to fill out the diagram narratively, and this was what was provided. Subject, Congress. Verb, shall make. Complement, no law. Prepositional phrase, respecting an establishment of religion. Or connects the clauses that follow. Clause 1, respecting an establishment of religion, comma, or prohibiting the free exercise thereof, semicolon. Clause 2, abridging the freedom of speech, comma, or of the press, semicolon. Clause 3, the right of the people peaceably to assemble, comma, and to petition the government for a redress of grievances. We have one subject, one verb or predicate, and 3 independent clauses connected to the subject and the verb by ors. Now, Merriam-Webster would then provide an assist to Captain Tate. Its online dictionary defines a clause as a group of words containing a subject and predicate and functioning as a member of a complex or compound sentence. Next, a lesson on semicolons from the dictionary. Webster says, semicolons, separate independent clauses that are related in meaning, and they separate items in a list when those items are long or include commas. For example, this summary could say, quote, "Semicolons are useful, semicolon, they show that clauses are related in meaning." That is exactly what we have in that one sentence that is the First Amendment. Captain Tate would tell the justices that the prohibition on free exercise is directed at Congress, not the states. But no one even raised the point. So how did this grammatical error come to be of constitutional significance? Well, the misapplication of the First Amendment to the states happened through a purposeful misinterpretation of the Due Process Clause of the 14th Amendment. The misinterpretation was a mystically created judicial doctrine by which certain provisions in the Bill of Rights were incorporated into the amendment's Due Process Clause. Incorporation was used by the court to apply various parts of the Bill of Rights against the states, even though all of the states had their own Bill of Rights. And that's how, through this doctrine of incorporation, the First Amendment directed to Congress came to be used against the states. It's been used by the Supreme Court to hold unconstitutional various state laws the majority of the justices, acting like policy-making legislators, didn't like. What precipitated this misinterpretation of the 14th Amendment? It was the unwillingness of the court to reverse a misinterpretation of the amendment's Privileges and Immunities Clause in 1873 in the slaughterhouse cases. In fact, in 2010, the majority of the court acknowledged in McDonald v. City of Chicago that, quote, many legal scholars dispute the correctness of the narrow slaughterhouse interpretation, end quote. I won't get into that case, but the point is this. Once the court got the Privileges and Immunities Clause wrong, it started making things up to get around its error, and not even a grammar lesson was going to keep it from stopping state laws a majority of the justices didn't like. I think Maryland's law as policy and as administered with no parental opt-out for religious reasons is horrible. But the justices are to apply the applicable law, not substitute their policy judgment for that of Maryland's elected legislators. So, if I were a snarky person, which I can be, and a justice of the court, which I will never be, because I'm in part too snarky, here is the snarky opinion I would submit. The Free Exercise Clause applies to Congress. As the footnotes show, history shows that the Establishment Clause only had one purpose: prohibit the national government from creating an ecclesiastical establishment that would receive the national government's patronage. Nothing in Maryland's storytime curriculum purports or threatens to do that. So parents, you lose. It's grievous for me to say that, but I suspect the Founding Fathers never thought a state legislative body elected by the state's voters would enact a policy with such a view of human meaning. It'd be contrary to the centuries of common law precedent, which is the basis of our nation's jurisprudence and informs the meaning of the words in the Constitution. But they left each state free to do that, if that's what it wants. The good news is that federalism means that those who don't like what their state legislature has done can, as Judge Robert Bork once quipped, vote with their feet. People are free to move to another state with storytime policies they prefer. We've been asked to rule on this only because this court applied a made-up doctrine of process, due process, incorporation under the 14th Amendment to substantively apply the First Amendment's prohibition on Congress against the states. In doing so, we ignored the plain rules of grammar, not to mention history. That grammatical error should not continue. It makes us policymakers instead of judges. Whether that doctrine should apply to all or parts of Amendments 2 through 8, we will decide when the particular issue comes up. But in conclusion, and on a personal level, I cannot in good conscience have Captain Tate continue rolling in his grave because others, before my time, forgot how to diagram sentences. I can see him now pounding on my desk with his infamous meter beater because I misdiagrammed the First Amendment. Let this haunting memory pound the desks of my colleagues who are mystics regarding the history and grammar of the First Amendment. Not me.